Hello, everybody, and welcome to Phoenixville Library, those in the room with us and those on Zoom, to our presentation today, The Basics of Landlord Tenant Law and Eviction Defense. And we're glad to have with us Kelly Young. She's a staff attorney with Legal Aid of Southeastern Pennsylvania. She'll do her presentation, then I'll turn off the camera, and then you folks can chime in with questions either on in chat if you're on Zoom, or you can unmute yourself, and of course those in the room can ask. Kelly, take it away.
Thanks, Mark. So like Mark said, I'm Kelly. Hi, it's nice to see everybody today. I am a lawyer who does mainly landlord-tenant stuff over in the Westchester office of Legal Aid of Southeastern PA. Our agency is a 4-county agency, so we have offices in Montco, Bucks, Delco, and Chester County, but the Westchester office is the only office in Chester County. So I'm here today to talk to you about the idea of defending an eviction case, which I guess we can open with the fact that eviction is a difficult thing. It's a very heavy topic. It's all well and good to talk about it in the room here, but I want to recognize that when it's really going on, it can be devastating. This is somebody's home and their life, and so this is a very, I respect the topic. So I have this PowerPoint, which we will follow through. Oh, I also wanted to say I printed out the PowerPoint this time, so if anybody wants one so that they can write their notes on it, feel free, and I have other brochures that you can grab at the end. Now, okay, so the landlord and tenant relationship in Pennsylvania is governed by these 4-ish important things, okay? The statute is the Landlord-Tenant Act. Very simple. It's from 1951, so as you can see, possibly needs an update, but that's what we're working with. The Fair Housing Act is, of course, applicable, which we're not going to touch on much today because that's a whole topic of its own. Pennsylvania court cases, especially Pugh versus Holmes, which is the case that established the warranty of habitability, the promise that the landlord will provide a habitable home, which doesn't necessarily mean a nice home, we'll talk about, but a minimally habitable home. And if you are going to magisterial district court, it might be helpful to take a look at the rules. So I've cited those. You could just Google that citation and they would come right up, and you can read, how are things filed, how are they served, when will the hearing occur, what if you need to ask for a continuance, things like that. And last but not at all least, your lease is incredibly relevant to govern the situation between landlord and tenant. And a surprising number of people that I talk with don't have a copy of their lease or never got one when they moved in. Very important to have a folder with all of your relevant documents, including your lease. Your lease is a contract, is the contract that governs the relationship between you and the landlord. Okay. Now, the Landlord-Tenant Act, I brought a copy here just because I like to bring things in physical form and show them, this is it, this is all, so not especially long, although I saw some, as if maybe it was long. Mainly when you're dealing with a landlord-tenant dispute nowadays, you're looking at Article 5, which covers recovery of possession. That's what they call it when they say, I'm taking the house back from you. Article 5 is written, I would say there are too many clauses, quite a few run-on sentences, but if you dig in there, you will be able to answer these questions, right? If a dispute comes up, what is my landlord going to do? What are they required to give to me? Who is going to make this decision? How is that going to work? Am I going to be able to stop the eviction? Do I have a right to do that? Or is this just, nope, recovery of possession? So it might be interesting to take a gander through here. It also deals with how you would recover your security deposit after you move out, and what to do if you leave and there are personal property items remaining that belong to you that you would like to take with you. So I read over it all the time, just brings me joy. Okay, so I like to tell people to keep it simple, because eviction, it can be very confusing, especially the court process. But to keep it simple, there are 3 reasons that I might be being evicted. Okay, there are 3 things that the landlord could allege against me, the tenant. Number 1, I didn't pay. That's a big one, and that's a common one. And that one can be solved, because if the only allegation is that you didn't pay, even after court starts and that process is moving down the road, you have a right to pay and cure the issue. Number 1 is I didn't pay. Number 2 is I have violated the lease in some other way. Not paying is a violation of the lease. That's a very specific one. Violating the lease in some other way is also fairly common. I'll see complaints for noise disturbance to such an extent that the landlord wants to evict me. Issue with a neighbor to such an extent that the landlord wants to evict me. Those are a little bit more difficult to deal with, but I do have a right to share my side in court. Or the final and I think final with a capital F allegation is that the lease term has ended. Okay, so the lease, it's a contract, like we said, and in Pennsylvania, we believe in freedom of contract. Freedom to contract with who we want to contract with, and when we're done and the contract has ended, freedom to not renew that contract if we wish. So like I said, this is often, like at the beginning when I said, you know, this could be a heavy topic, I have spoken to people who have lived in a home for 20 years. And maybe they're on a year to year to year lease, maybe they're on a month to month lease for all those 20 years. But if the owner at some point decides, I don't want to renew the lease after the next term end, as long as they notify me with enough notice, look in the lease to see what's enough notice, I have nothing to say to that. That's a non-renewal, and there is no legal defense. So the one thing I'll say on non-renewals as well is check the lease, because I have also spoken to people who receive the devastating notice in the mail. I'm the owner of the home. A lot of times the home sells and the new owner will do the non-renewal, right? Because the new owner is inheriting the lease that the previous owner had with you and all of its terms. So, you know, I received the devastating notice in the mail. I won't be renewing your lease at the end of the next term. Please leave by May 31st. And I'm crying and I'm so upset and I don't know where to take my family. But then I look at my lease and I see that actually the term doesn't end until August 31st. You know, you have to do a little digging to make sure that the wool isn't just being pulled over your eyes, or that the landlord isn't just making a mistake. Sometimes it's an innocent mistake, especially if you have a lease that is year to year. Say you move in, you sign, it says May 1st to April 31st of 2016. And then there's no, like, come on in and sit and feel free. And then this is about landlord-tenant law.
Yes.
So say you had signed a lease in 2016 that was for a year, and there's nothing in the lease about renewal, okay? But you're still there, and here we are, it's 2024. Well, then your lease automatically renewed on a year-to-year basis. So those dates, April 1st to March 31st, would be applicable to this year. And if I'm getting a non-renewal notice telling me to leave on a date other than March 31st, that's just incorrect. So you could very politely push back before it gets to this point where you didn't leave and they're filing an eviction with an allegation of non-renewal of lease. Okay, so those are the 3 reasons that we keep in mind. Those are the 3 things that might bring me to landlord-tenant court. So if I get taken to court, where am I going? Well, the landlord-tenant cases always originate at the lowest court in Pennsylvania. So this is our state court system in a beautiful triangle. And the Court of Common Pleas here, the second from bottom, is the Westchester County Courthouse that everybody thinks of with the big columns, and it's very stately. Okay, so it doesn't start there. That's the next level up. it starts in the magisterial district courts. And even though that's a longer, fancier name, it's a more accessible court. So there are, and don't quote me, but I believe 15, 16 or so of these in Chester County. There's a directory online, and your township dictates which MDJ, we call them magisterial district judge, which MDJ court you will end up in. Now, after the result, after the hearing is heard and there's been a decision, if you'd like to appeal, you're headed up to the Court of Common Pleas in Westchester. And no matter what the case is, there is always an appeal period and a right to appeal. Okay, I'm questioning the order that I put the slides in, but we'll go with it. So, if there is a dispute and the landlord feels that one of those three things is happening, you failed to pay, you created some other sort of violation, or your lease is over, they notified you properly and you have not left, then they can sue you. How would that happen? First, they need to give you a notice to quit. Okay, that's the notice where they say, I believe you didn't pay. Please leave in 10 days. Only after the date in the notice to quit has passed can they sue. If you get a notice to quit and it says, I believe you had a completely inappropriate argument with a neighbor, which was a violation of the lease, I need you to leave on October 31st. And then they sue you on October 16th, well, the court doesn't have jurisdiction yet, because it's very clear in the law that the court only has jurisdiction after the quit date has passed. I will say a lot of leases nowadays, and what we're having happen is all questions held until the end, and then I'll take any and all questions. The leases nowadays are often form leases, right, that are more in favor of the landlord than they are in the tenant's favor, and they will often say that the notice to quit requirement from our friend the Landlord Tenant Act is waived. That's legal. It is legal for the notice to quit to be waived. So if your lease says that, you could be sued out of the blue. Doesn't mean you don't have a right to a hearing, doesn't mean you don't have a right to share your side, but you don't have a right to that notice warning you, I'm about to sue you. Certainly read a lease before you sign it, and if that's in there, you can negotiate, right? Oh, you know, I'd really prefer that we have the notice requirement. That way it benefits both of us because we can potentially work this out before you spend $170 suing me. You can have that conversation, but if it's a complex, you know, one of these large corporations, they're not gonna bend, which is frustrating, but that's the way it is. So, the landlord gives you the notice to quit. Now, unless it says otherwise in your lease, the notice must be hand-delivered or posted on your door. It can't just be mailed to you. The non-renewal notice, that can be mailed to you, that's fine, because that's just a non-renewal of your contract with the other party. But a notice to quit indicating that the landlord believes there's been a violation, it must be personally served or posted at your property door, and that's because it is considered so important, even though we allow it to be waived. So lots of nitpicky rules. After you get the notice to quit, maybe you try to resolve it, maybe it's not possible, and the notice to quit date has passed and you have not left. Okay, if you choose to leave, fine. But the only way to enforce your rights is to stay and allow the process to start. You will receive a complaint in the mail from the court, service on you of the landlord's complaint. There will be 3 pages. One is just a notice that you've been sued, one is the notice of a hearing date, and one is the most important page, the complaint. And again, because I like paperwork, I also brought QV Homes if anyone wants to look at that at the end. This is what the complaint looks like. It is simply 1 page. You know what? This is the wrong one. So please, scratch that. Bear with me. It is only 1 page, but it looks like this. And the landlord is simply required to, and they make this easy. The state legislature made this easy because you're not supposed to need a lawyer at the MDJ level, okay? You can have a lawyer, that's fine, but it's supposed to be accessible to the layman. So the landlord simply must fill out what is your monthly rent, what is your security deposit, and check a box, okay? The box that they check, it is important, and we'll get to that, but it's not hard, right? It's just a check mark. And they sign their name, they file it with the court, pay the 170 something, and again, you get service. You get notice of the court hearing. You need to receive that notice at least 5 days before the hearing. If you did not, if for some reason you get it and the hearing is the next day, by all means call the court and say, you know, I didn't have the 5 days, I don't understand, but service was late and I'm asking for a postponement. A lot of the time they'll say, well, email that to us because we need that in writing. The hearing. So you go to the hearing in person, again, don't need a lawyer. It's a very small hearing room, not like what you see on Perry Mason. And
Thank you so
typically, the only people in the room are the people involved in your case. You can have a witness, that's fine, but many people don't. They just testify on their own behalf. They are their own witness. After the hearing, the judge will rule. The judge can rule on the spot, or the judge can rule up to 3 days later. So if it's complicated, the judge will want to take the paperwork that you brought, look things over, and make a decision, in chambers, in quiet. Now, the judgment will be mailed to you. So you'll receive that. It's called notice of judgment. That's what it says at the top. And when you get that, read that carefully. It can be confusing the way it's worded. I also brought a copy of those. But it will tell you, number one, how much the judge has determined you owe, and number two, if possession has been returned to the landlord or not, if possession was awarded. It'll also tell you if your decision is a pay and stay, meaning, like I said before, the only problem was money, you can pay it and you can cure and you can stay. Or if the decision was what I call a straight possession, which is just a nickname that I have for it, which is the kind of possession where there's really nothing you can do to cure the problem, you are gonna have to leave. If it's that kind of judgment, you may be interested in filing an appeal. The appeal period is quite short. It's 10 days from the notice of judgment entry date. Not the date you receive it in the mail, the entry date. 10 days if you wish to dispute possession of the property as well as the monetary amount. So for example, I'm in the property, I was sued, the judgment comes and it is against me awarding possession back to my landlord, but I disagree. And I want to keep living in my house while I dispute the decision, while I appeal the decision. I only have 10 days to file that appeal. If I'm leaving the house because I'm just done, I'm fed up, but I want to dispute the money portion of the judgment, then I have 30 days to file that. And any appeal is filed, like we saw here, at the Court of Common Pleas at the next level up. Now, if there was a judgment for possession for the landlord and I don't appeal and it wasn't a pay and stay, or it is a pay and stay but I don't pay to cure, then there's gonna be another step, okay? The notice of judgment is not the paper that evicts you. There's another step. After the 10-day appeal period passes, the landlord can return to the district court and get the order for possession. That is a paper that looks so. It's 2-pager, and it also will be posted at your door, very unfortunately, and we'll give you an exact date and time that you need to leave the premises. So there's that. And I have, if anybody wants to look at these, we can look at them at the end here. Okay. Now, you need to look closely at the complaint, because what is pled on the complaint controls the hearing, okay? You're gonna go to this hearing and you're gonna wanna defend yourself. Well, against what? Against what is pled, okay? So sometimes I'll experience the landlord files a document like this, and I hope everybody can see this, but I know people in this room can't, so they indicated that the rent is $1,000. That the issue, the checkbox here is rent remaining due and unpaid, okay? So the allegation is you didn't pay $3,000, and that's it. That's the only allegation. So now you go to the hearing if the landlord, who gets to speak first as the plaintiff, starts to say, well, the money hasn't been paid, and I'm just really frustrated because every day they're out in the yard creating a disturbance. Okay, respectfully, you object to that, because that's not at issue here. The fact that you're creating a disturbance you haven't been notified in the complaint that would be brought up. So it's not relevant to the proceeding. And I always recommend be professional, be polite to the MDJ as well as everybody else in the room, regardless of the situation and what's happened between you. Objecting doesn't have to be rude. You have a right to object. So respectfully, I object to that. That was not on the complaint. This complaint, to be proper, would actually have to have a bit more. They did indicate that rent was owed, but under number 4, they need to indicate whether they served me with a notice to quit, like we talked about, or whether the notice to quit is waived by the lease. They didn't check either. So if I receive this complaint and I'm a tenant and I go into the hearing, I would say, respectfully, there's no jurisdiction yet because the plaintiff hasn't pled anything about the required notice. In that situation, sometimes you can just buy yourself time, right? Maybe the hearing could be continued, which is what we call it when it's postponed, for 2 weeks. And maybe then you're able to work something out. Maybe then you're able to get the money that you needed to get. You can also waive the defect if it's really not gonna help you, if it's not a leverage on your side. So this complaint, if it was proper with the checkbox under one of these quit options, could only result in a pay and stay judgment. Okay, the only kind of judgment that I could receive is one that tells me, yeah, I'm awarding possession back to the landlord. But you can stop that if you pay what I say you owe. If I received a judgment in the mail, my notice of judgment, and it was a straight possession, that's just plain wrong. And it happens, and it's a shame because it's plain wrong, but a layman wouldn't know that it was wrong, right? And would just think, oh, well, now I have to leave my house. Well, no, that's the wrong decision, and you should contact a lawyer. Because what you can file in that situation, you can always do an appeal, that's fine, but there's something else for when a decision is wrong like that called a writ of cert, and that is probably more easily done with a lawyer. Okay, so if there was a complaint filed, such as this complaint, okay, you owe some rent, I didn't have to give you any notice because my lease is waiving that, and a forfeiture has resulted. This is the box that the landlord will check if they're alleging not only unpaid rent, but another violation. Noise, crime. It could be anything. It could be having a pet. Maybe the lease says you're not allowed to have any pets and you have a cute little dog. Well, that's gonna be an eviction complaint. So, this one here says, the allegation is a forfeiture has resulted by reason of a breach of the lease. To wit, of course they have to have the words to wit. Non-payment of rent, okay, no. That's just a repetition of what was above. You can ignore that. That's not a separate allegation. Breach of lease, pet violation. Okay, so there you go. At the hearing, what can be spoken about, what can be testified to by the landlord who speaks first is just the pet. How do they know you have a pet? And how do they know that's not allowed? So they have to bring the lease. I can't believe, sometimes the landlord goes to the hearing without bringing the lease, which is, don't you supply it, that's the plaintiff's job. Lost my train of thought there. Those are the only things that can be discussed, right? Any other allegations, well, I respectfully object because I wasn't notified that that was a claim, therefore I didn't have time to prepare my defense, what I was gonna say on my own behalf. Okay, so this kind of complaint for rent and forfeiture, whenever forfeiture is checked, you gotta worry a little bit more, because that means you could be coming out of the hearing with a straight possession judgment, which is, there's no opportunity to cure and continue your housing. I have a little bit more detail about a hearing, so the plaintiff always goes first. Again, this is, if this is me and I get sued, I'm upset. I'm angry. I want to have my say. I could be very emotional at the hearing. Don't interrupt the plaintiff. because the MDJs are tired of that. They hear these cases all day long. They like order, right, in the courtroom. So allow the plaintiff to go first, and if the plaintiff is saying things with which I strongly disagree, I take notes for myself, okay? Maybe the plaintiff says, well, Kelly, she's just no good. She's always selling crap in the front yard, and then the police come and she yells at the police, and none of that might be true, okay? But I wouldn't just say, oh, that's a lie. Oh, that's not true. Let me tell you, Your Honor, what actually happened. No, you can write it down. You can make a note that that's a point that you want to address, right? And then you wait until it's your turn. After the plaintiff presents her case, only what was in the complaint, anything else you had objected to, then you present your case, okay? And with your case, you can have a witness, sure. Maybe the allegation was that you have a pet, but you have 2 neighbors who know you very well and know that you don't have a pet. Okay, they can come and testify, although oftentimes they won't want to. And that is the hearing. I'll take questions about the hearing at the end. Okay, again, I'm throwing it in here. Your lease. You should pay much attention to your lease. Sometimes the allegation in the complaint is something that is allowed in the lease, right? Maybe there's an allegation that there's been a pet violation, but you have an addendum to the lease that allows you to have your dog Sandy and your cat Arnold. So, and attend to the term. Always attend to the lease term. Okay, here I actually have examples of a waiver of notice to quit requirement. So, and I have the law. This is from the Landlord Tenant Act, okay? So, again, with our old-fashioned language, a landlord desirous of repossessing real property, a house, from a tenant, notifies in writing the tenant to remove from the same at the expiration of the time specified in the notice under the following circumstances, blah, 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 blah. It just means you have to get the notice. Here's the part that tells you, okay, this part doesn't tell you that it has to be personally served, but I'm telling you that. But this part tells you the notice shall specify that the tenant shall remove within 15 days when the lease is for more than 1 year. Okay, I think the words are too close to my face. The notice to quit requirements in the law have a required time. So it has to be at least 10 days, okay? It can't be 5 unless that's in your lease in the waiver. But I think I just put this here because I wanted to show it might be this small. You might have a 10-page lease, and on page 4 they have this: landlord shall not be required to give tenant a notice of default. That's waived. Now, if it's that small and it's not bolded and you didn't initial it, you didn't get a notice and you were sued out of the blue, you can make that argument with the MDJ. It's going to depend on who your MDJ is. Some MDJs are quite, I guess we'll just say tenant friendly, and others are more, I really don't care. So if the notice to quit waiver has been buried in the lease and you just had, there was no way that you could have seen that. Some leases are 60 pages. You can make that argument, you know, Your Honor, this is not appropriate. This clause in the lease should not be enforceable. Very well may not fly. Okay, so speaking of unenforceable terms, I had really hammered on how important your lease is and how it dictates the relationship, but sometimes, actually somewhat frequent that I see, there are things in the lease that are just not legal. For example, it may say, the tenant accepts the property as is, right? And that's fine. Maybe you saw it, and when you moved in, you accepted the way it was, but since then, in the past 6 months, the hot water heater has broken and the ceiling fell down because of the leaks that were happening, right? I've seen that. Well, no, you're not accepting that as is. That's a violation of the habitability warranty that we talked about earlier. So That's an example of something that is unenforceable, right? I'm accepting the property in whatever condition it's in. Sometimes it will say, tenant is responsible for all maintenance. Again, unenforceable. And also, why would you sign something that says you're responsible for all maintenance when you don't own it? Never do that. Daily increasing late fees. Okay, so in a contract, you can have a late fee clause, okay? If I don't pay my rent by the 5th, then I need to pay a $100 fee with the rent when I ultimately do pay it. Fine, but it cannot say I have a $100 fee on the 5th, on the 6th, and also a $25 per day fee. That's not allowed in Pennsylvania. Maybe in New Jersey, maybe in Delaware, I don't actually know, I don't work there. But in Pennsylvania, you cannot have a late fee that accrues daily. That's considered an unenforceable penalty clause, right? Because it's clearly to pressure you and create a scary penalty, right? And so that cannot fly. I have seen some MDJs go with that. They allow that. You have to push back. All right, here, what did oh, this is a big one. Sometimes you'll see a lease, these are usually older leases that say that, you know, there's a confession of judgment. The landlord doesn't have to take you through the court process. Okay, that is never, ever, ever a thing. In Pennsylvania, the only way to have me evicted from my house that I rent is to take me through the court process. You cannot just change the locks. That's an illegal eviction. That's an illegal self-help eviction, and if that happens to you, call the police and have something that proves your address. And if they're not helpful, which usually they will be because the police know that this is a civil legal issue and must be taken through the court, then you would call a lawyer. Because there could be a, you know, depending on the situation, a complaint and a petition for injunction filed to say, let me back in my house, this is wrong. So in Pennsylvania, I have to be sued and there has to be an order for possession, this page. There has to be this page to get the constable to come and take me out of my rented property. There is no other way. So this example, and these are all the things that I'm showing here are things I've had in cases at legal aid. So they're not, you know, they're not made up. Says, remedies upon lessee's default. Upon the occurrence of any of one or more of the events, the following remedies are available to lessor. Lessor may immediately declare this lease to be terminated. Lessee authorizes irrevocably the prothonotary, the court office, to confess judgment without process in favor of the lessor. No, there is no judgment without process. So be on the lookout for things in your lease. If it sounds wrong, it may be wrong. Although to me, the notice to quit waiver sounds wrong and it's not. We really already talked about the term. A lot of leases will have a renewal clause that says at the end of this first year, we're automatically month to month. Fine. If they don't have a renewal clause, but you're still there, they're automatically renewing with successive, how do I say this? With the same term length. So if you were in there for 6 months and the lease is silent about renewal, and it doesn't say this lease ends and does not renew, then you're there for successive 6 month terms. So maybe you don't have a new lease that you sign every 6 months with the landlord. That's fine. The terms in the original lease control. You don't have to have a new signed every year lease. It's better, probably. Everybody's on the same page. But if you don't, the lease you had originally still controls. You just have to use your mind to update the dates based on the renewal clause. Right, so I had talked about how there are instances where the landlord sends a notice of non-renewal and it's wrong because the lease isn't actually over. So be attentive to that. And what else? Okay, sometimes the situation is, this is about the habitability issue that we touched on earlier. Sometimes the situation is that you were sued for non-payment. But it's not that you didn't have the money, it's that the property is falling down and you withheld your rent to put some pressure on your landlord. Okay, in some situations that's fine, and you can win a case if you have followed the correct procedures, okay? So the warranty of habitability comes from Pew v. Holmes, which I brought, which is about 10 pages, and which is quite interesting to read. And it recognizes that the tenant doesn't have the same power that the landlord has, and this is an unequal relationship. And that the landlord has certain responsibilities to provide the tenant with a livable home, okay? So, needs to be fit to live in. This cannot be waived by the lease, unlike the notice to quit. And I have a picture here from this book, which is a great book that talks about a lot of different tenant rights, and it has a whole sample section about the habitability warranty, so feel free to take one of those. So, if you have no hot water, God forbid the sewage system is not working, which I have had, you can't open the windows or you can't lock the door. There's no heat, the roof is leaking, or the wall is, leaks, serious leaks. You have no electricity, or possibly the floor is buckling. None of those things are okay. So in that situation, but if you need painting, that's not, it's a problem, but that's not a habitability problem. If you need new carpet, yeah, it's a problem. It might affect your confidence having guests and things like that, and that's not fair, but that's not a habitability problem that you would withhold rent for. So if you have one of these problems, hopefully everything is gonna be fine. You call up the landlord, I call up the landlord, I say, okay, my toilet's not working. Landlord says, oh, no problem. I'll be down there tomorrow and we'll get that patched up and everything's fine. Sometimes there's a situation where the landlord is not properly attending to her duties. So I send something in writing, okay? Because you want everything in writing for when you go to the magisterial district court. Something brief, something concise, something polite. Here's the date, here's my address. My toilet's not working. I need you to help me come and fix this within the next blank. And you as the tenant, or me as the tenant, gets to choose a reasonable time within which the issue should be fixed. So if you have no heat, you can say, please help me in 24 hours, okay? It's January. If it's something more like the floor, maybe it's a vinyl, maybe it's a tile floor and it's chipping and it's really dangerous and unsafe for walking, that is something that might take a little longer to correct. So maybe you say, please help me within 2 weeks, right? You'd be reasonable is what you want to be. That's what the court is always looking for, reasonable person. That's what they teach you in law school. And you're like, who's the reasonable person? You send that first letter, okay, and you keep a copy of what you sent. It's better I think it's good to email it, because then you have that email, it's clear that it was sent. You could do a read receipt, or you could do certified mail, but that can come off as a little bit more aggressive. Or you can personally hand it to the landlord. You can have a face-to-face with them and say, look, I know we talked about it, but I'm also just giving you this just because I wanted to memorialize what we talked about. If you, I just forgot what I was going to say. Sample letters are in the book here. All right, then you wait. You wait that amount of time that was reasonable that you suggested, and the issue gets fixed. Great. But if the issue doesn't get fixed, you send another letter and you say, I hate to have to do this. I hope we can work this out, but the property is still not livable, and I'm going to have to start escrowing my rent on the 1st of the next month when money is due. And then you don't spend the money on anything else, because you have to have the money to win a habitability case in district court. You put the money that you would have paid the landlord into a bank account. Maybe it's an empty savings account, maybe you open up a new bank account and call it, rent escrow. And you continue doing that on the date that the rent is due until the issue is fixed. Now, major warning, major all red capitals. If you're on a month-to-month lease and you have a landlord that really just can't be bothered, there is no good retaliation protection law in Pennsylvania. If you start to escrow rent and use this process and put pressure to get things fixed for yourself, which is reasonable, right? I have seen it happen. You might receive a non-renewal notice. And is there a legal defense to non-renewal? No. So, whenever I talk to people about this, I check their lease term. And if they're in a lease until August and they're going through this process in January, fine. You're secured from that kind of retaliation. But if not, I proceed with caution. Maybe talk to a lawyer or legal aid. So that's option one, is to just escrow the rent. Option two, if it's a small thing, you can hire somebody. You can keep the receipt. You can deduct that from your rent, and you can pay the remainder. Okay, sometimes that's simpler because it doesn't go on forever until the landlord fixes it, which they may never do. It's done and it's resolved. If it's something so unbelievably terrible and you just cannot live there, for example, the ceiling actually caved in and the landlord is ignoring you, which I hope that doesn't happen. I have not actually seen that one. A lot of times they care. This is just an extreme circumstance. Then you can terminate the lease. But again, I would talk with a lawyer. But it's the same pattern. First letter, the ceiling caved in. I can't cook. I can't access my bedroom. Second letter, because this is such a severe problem, I notified you and there was no response, I'm terminating the lease, right? And then you move out. And then the ball is in the landlord's court. If they choose to sue you because you moved out before your lease ended and they want all the money that was due for the rest of the term, well, you're gonna be prepared because you're gonna walk into the hearing after you get served and you read the complaint, and you're gonna have your first letter, your second letter, and the photos of your home, which is not okay. Okay. Now, this is a slide that shows how the notice of judgment looks. So the other slide, we saw the complaint. We talked about how what's on the complaint dictates what's on the notice of judgment. Okay, this is a pay and stay. And I don't know why they can't just write, you can pay. But what they have to write is, possession is granted, and at any time before actual delivery of the real property is made in execution of the order for possession, blah, 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 the defendant may pay the rent in arrears and the cost of the proceedings and satisfy the delinquency. Okay? A lot of people can read this 3 times and still not know what it means. So it means you can pay and you can stay. This one is the scary one. Possession is granted and the defendant is not permitted to satisfy the order for possession by paying the rent in arrears. And here's a picture of the order for possession. Okay, like I said, they hand write in the time and the date. On the second page, there's always some information about at midnight of this day. No, it's not midnight. The constable's not coming at midnight. It's usually 9 or 3 or something like that. And the right to appeal. I think we're just gonna move on to questions because I did somehow talk for a very long time. PA Law Help is a great website for a lot of different civil legal issues. They might have some stuff about criminal law on there, I can't recall. But I have a picture of the website just to show you how it looks. And there's even a video that you can watch. It's like a skit of an MDJ case. And I watched that when I was new. And here we have our contact information and a couple other places that provide free legal services. Of course, we have income restrictions. So, anybody else have a question or
We'll
want to?
stop the recording at this point. Thank you, Kelly.
Thank you.